is April Paredes, and I will be moderating today's program, Building Compliant Partnerships in the 500 Billion Creator Economy. This rapidly growing space blends IP challenges, AI content, and shifting regulations far beyond just influencer marketing. Whether you're an entertainment attorney or simply curious about this legal landscape, we are glad you're here. I'm delighted to introduce our speakers, Tisha Morris, Nyanza Shah, and Matthew Dysart. Tisha Morris is the founder of Legacy Arts Law PC, dedicated to helping artists and creators build and protect their legacies in entertainment and publishing. Tisha is a best-selling nonfiction author and the host of the Entertainment Business Podcast, where the creative life meets the business of entertainment, turning dreams into reality. As a Nashville and Tennessee native, Tisha began her legal career with 2 federal judicial clerkships before practicing law for over 2 decades. Nyanza Shah is fueled by a passion for the creative industries and has helped numerous high-profile projects, providing strategic advice that transcends conventional legal frameworks. Her keen insight into industry trends and unwavering commitment to protecting her clients' interests have made her a trusted advisor and a respected authority in the legal field. Nyanza specializes in helping businesses and brands bridge the gap between the creative ventures and business operations to maximize growth and impact. Matthew Dysart is an experienced entertainment attorney with deep expertise across television, feature films, podcasts, digital media and technology, and the creator economy. He has handled more than $2 billion in corporate development, M&A, film and TV slate finance, and production deals, acting as outside general counsel and deal advisor to production companies, creators, and tech firms. Matthew's practice includes representing several leading podcast, digital media, and film and television production companies and talent, many of which leverage their brands into successful consumer products, publishing, and live event ventures. And now let's get started. Next slide, please. So this is our agenda. We'll be touching topics on emergence of the creator economy, monetization strategies and legal pitfalls, emerging regulations, and then we'll finish our presentation with Q&A. Throughout the presentation, feel free to send us your questions and we'll address them at the end. Next slide, please. Market snapshot. So let's start by understanding the size and structure of the space. The creator economy is no longer a side hustle. It's projected to be worth $500 billion globally. Over 200 million people identify as creators, and nearly 40% do it full time. Platforms like TikTok, YouTube, and Patreon have allowed individual creators to build direct-to-audience businesses. But with rapid growth comes fragmentation and often confusion and about rights, responsibilities, and revenue. I'm going to direct this question to Tisha, but Matthew and Nyanza, please feel free to chime in as well. So Tisha, how has the rise of the creator economy changed the kinds of legal issues clients are bringing to you?
Thanks, April, and thanks to the Beverly Hills Bar Association for hosting us. Well, first off, we are in a time we've never been in. This is a very exciting place where the creator economy has merged with the more traditional entertainment space. And so there are all kinds of mashup of issues that are playing out, and one being with brand awareness being a strong part of the content creator, with FTC challenge or compliance issues coming up, ownership being a big hot topic in the content creator space, and obviously in all forms of entertainment now because of the content creator space as well. So it's just a really interesting time with new issues coming up. The main one being ownership, which I'm sure we'll expound on throughout today.
But in terms of like the legal unique challenges that you've experienced, right, with your own list of clients, what has changed in terms of like are there like novel issues that your clients are bringing to you that you've not necessarily seen, but because of this space that's been created?
Well, because of the emergence of the content creator space, there is more leverage they have. And so, like I said, the ownership, but approvals, specificity on deliverables is always needs to be fine-tuned, and also the shift of liability, who is going to take the brunt of the liability. And so really negotiating on behalf of my client, my content creator clients, is the side that I'm usually on. And so really making sure, number one, they are aware of what they're signing and what needs to be changed so that it is more drafted in favor of them, or at least on a 50-50 level. But definitely, I mean, pretty much every point in the contract, termination clauses, deliverables, exclusivity, ownership. Yeah.
As the creator economy continues to mature, we're seeing more creators function like full-fledged businesses. So they generate revenue, they're signing contracts, they're hiring teams, right, and building brands. But unlike traditional businesses or even entertainers representing by agents or studios, many creators are building this from scratch, often without legal support early on. What are some unique challenges, legal challenges, you would say, content creators face compared to traditional businesses that are just starting out?
I'd love to
Well, the
address that
interesting,
if possible, April. Or Tisha, do you have a
no,
specific?
you go ahead, Nancy.
Um, as Tisha mentioned, as the content and creator economy is growing, they are moving towards more production studio based. Is different than just a pay to post, right? So the difference is that they're going from technically creating content to producing content. And so it's not necessarily that there are some new legal challenges that are coming up, but I think that they are in their growing pains realizing that there's different types of deal structures that are now applying to the type of business that they're now operating, whether it's, by the way, from scratch, even setting up a company, setting up a production company, how they're engaging and producing content beyond, you know, on their phone specifically for a platform. And so then that goes into the types of deals that they're doing with brands and with corporations to see what platform is this going to be on, what type of content are they creating, where is it being shared, and then it goes to what Tisha was talking about in terms of all the deal structures that come into play along with that growth.
Right.
I'll add one comment to that. I think it's a really valuable response. Um, one of the things we see with traditional businesses or entertainers is that when they get ready to form a company and establish a brand, adjacent to their primary work as actors or writers or directors, and so maybe now they're venturing out into consumer products or consumer packaged goods or related ventures. Um, by that point in their career, they've often got a team. They've got a team of professionals and they've got access to a lot of capital. And they may even have a production company established already that they can begin to operate these ventures through. And so they're pretty well professionalized and they have access to a lot of professional assistance to make sure that as they build and launch new businesses, they do it in a smart way, in a risk-adjusted way. And so with our traditional talent, we often see that they're surrounded by very highly qualified financiers and operators. For our creator clients, it's often surprising how quickly they mature into becoming platforms. Because the barriers to entry are so low, and production and distribution is so easily available to them at scale. They reach that point sooner where they're able to branch out and launch and operate businesses. It might be a studio business or it might be a consumer product. Um, and so they don't always have access to a strong team, great, well qualified financiers, top tier operators, lawyers, and other advisors. And so we do see creators sometimes launching businesses without the infrastructure you need to for that new venture to go well, to land well, to avoid product risk, messaging risk, comms and PR problems, and then other kind of execution risks of a new business. And so we see a lot more operational hiccups with creator-backed businesses. And so one of the things that we see kind of emerging to fill the gap in the marketplace that this creates is this joint venture between talent and platforms, businesses that have been established to help creators launch these brands and operate companies without having to hire the full team themselves and build all of the back office and even front office infrastructure you need to run a business. And we'll talk more, I think, about that business model in this conversation. But that model is, I think, uh, one of the more interesting things emerging in the creator space, and one of the more successful approaches that we see our clients taking.
In regards to your response to the question, Matthew, and you mentioning, these creators are having teams, right? Um, so we understand that the creator economy isn't just made up of influencers. It's a web of players, including creators themselves, agencies, or managers who represent them, right? And the platforms that distribute and monetize their content. Each of these players serves a different role, but those roles often blur in practice, especially when it comes to their legal rights and responsibilities. So, in this ecosystem of creators, agencies, and platforms, how should we think about the respective legal rights and responsibilities?
So I'll jump in, kind of pinging off what Matthew said. Depending on at what stage of their business they're at, they either have a full team or just themselves, and that's going to determine a lot. But overall, it is an area of entertainment that's kind of disrupting the whole model, like the agent model, the studio model, and it kind of is a little bit of a Wild West as far as the traditional roles that the players play. But at the end of the day, the legal agreements are still about the same as far as what needs to be negotiated or how they need to be protected. But really, to Matthew's point, shifting or not shifting, but the attorney being as much of the business attorney as the entertainment attorney, taking on that role of how they're setting up their business. Do they have the right team players? Do they have their own agreements in place with their own work for hire people that are working for them, having all those pieces in place.
Right. And with that, let's go on to the next slide so that way we can focus more on the legal challenges for creators. I think that's a nice segue for that. So one of the biggest gaps, as we've been, talking about in our conversation so far, that we see in the creator economy is that many creators start building a brand before they build a legal foundation. They're posting content, signing deals, and monetizing their work, often without clear contracts, IP protection, or even a business entity in place. And when something goes wrong, whether it's a copyright dispute, a brand disagreement, or a platform issue, that's when the lack of legal infrastructure can cause serious damage. So, what are the most common copyright or IP disputes that, in your experience, you've seen that creators face, and how can these be avoided early on?
I'll jump in here. I know both on actually the talent and the brand side, one of the challenges that come up is even the initial protection of the IP, because they're going to do a deal for rights. And it's like, well, what have you done to establish your ownership in these rights before you're granting any rights to a third party, right? Whether it's a brand, whether it's a platform, et cetera. And so when they are kind of cart before the horse on creating content and not having their business structure set up, that's a challenge that comes up where it's like, okay, well, you have to be able to show a brand that you own the IP, right? Before you can even monetize it, before you can even exploit it. And so that piece is that first piece. And then I think going to even identifying the scope of rights and how they're being used, who they're being granted to, et cetera. And I will mention quickly here in terms of monetization, because this doesn't come up as often, but I've also worked with brands and doing branded content and et cetera. And it's actually a very interesting gap even between their knowledge of how to do these deals as well as the creator talent side's knowledge of how to do these deals. And so I have been in places where we're educating the brand on what is your ROI? What are you trying to get from this content creator or influencer so that we can structure the best deal for your ROI, right? Because it's not just about making a post, or it's not just about, they'll say, because they don't know, yeah, we do want something live for a year, but we know in real time, keeping something on, your feed for a year really isn't any of value. And so those kind of knowledge gaps. So I think it goes from the ownership piece, determining what the rights are, and even the knowledge gaps on both ends of trying to figure out how this deal works for both parties in terms of going to those the ownership piece of who's going to retain ownership, what's going to be granted, et cetera.
There's two, I think that's a really good, there's maybe three actual um, real big kind of challenges I see working with brands in these deals, Nyanza. One is ownership, like you said. We often see brands initially taking the position that they should own the creator's content in a brand deal. And I have, a pretty hard and fast rule. There's only a few cases where it makes sense for the brand to own that content, and that's when they're really hiring the talent as an actor for
Yeah.
a commercial or campaign that the brand has previously produced. But if it's social content, if it's creator produced content that's being distributed on their channels, um, we have a pretty firm rule that the creator must own all of their own content. We also see brands often refusing to provide indemnity for content that they create, intellectual property that they contribute to the creator for inclusion in a deal. We get a lot of pushback on that point, and have a pretty hard rule there as well. If the brand is contributing something, they should stand behind whatever that intellectual property represents, whether it's if it includes music, if it includes their trademarks, whether it's other just sort of creative format related contributions that they make as part of their review process on the content. And then the third is insurance. It's critically important that the creator is covered by the brand's insurance policy for the campaign that they're engaging in.
When you are negotiating these brand deals, right? And there's like a set time of when they can use the creator content or for a period of time. Are you seeing that brands want to use that content like indefinitely, or they want to use it on different platforms that wasn't originally negotiated? Or what pushback do you see from brands in terms of like when they want to, I guess, license the content for a period of time and use it for other purposes?
Well, I think all those guardrails need to be put in place in the contract, and I think you've kind of hit on the nail of what those negotiated points are. Um, is how I see it.
And it's the mass point where it isn't necessarily just about the ownership piece of it, but it is really specifically in this creator economy, how it is being used, where it is being used, and how long it's being used.
I
What would
find that our brand partners are pretty thoughtful about structuring parameters around those use cases. So when and where, and how much paid promotion they can provide behind a post, that sort of thing. Um, and they're responsive to the lawyer
Mm.
that asking to define those things carefully, because that's really that half the rate card is how it's being used, and then the other half is like what price they're going to pay for those uses. So, um, definitely important to make sure that the brand is not getting unlimited usage rights, perpetual usage rights for all media without paying for it.
Yeah, and as I mentioned before, we see that some brands realize that when we're saying you're not going to just use it in perpetuity or you're not just going to use it broadly, they understand. It's like, okay, if you're paying this price, this is the value proposition of what you're paying for. But also, this is, again, what is the benefit for what you're paying for that you're trying to achieve from this partnership? And that isn't usually, again, use in perpetuity or use on all platforms because they do want to be smart about getting a return on their investment.
Exactly. What would you say is the most overlooked clause in a typical creator agreement, and why is it important?
Hmm.
I'd say one. I mean, we could really riff on this question a lot, but I think one important one is the termination clause, in which is I kind of think of that in terms of almost all contracts as termination clause, but specifically with content creators having a morals or cancel clause on both sides, not just on the creator, but also to the brand. So I think, and just having, reasonable outs on both sides.
I think the other one that comes up a lot is exclusivity. And when you are defining what an exclusive market or exclusive industry is, and sometimes, and again, I think generally brands who want to do business in this space are open to advice from the lawyer, but it is that it's not going to be the entire wellness space or the entire drink industry, or, and you're trying to umbrella things where it's like, okay, let's figure out how we can work together and not feel like there's any conflict with competing brands in a more reasonable, justifiable way that isn't blanketing and blocking the content creator from also doing other deals that may be in similar industries but are for totally different products that might overlap but are not competing.
Right. I know we've talked about this in the beginning that creators are operating more like businesses now. At what stage should a creator formalize a business entity, and what risks do they face if they delay? Because they start off like just posting content, right? And then they start getting a large following, and then often the times is that they forget to formalize their business. So, can you speak a little bit about that?
I would say pretty early, again, because that might be part of the conversation in regards to the ownership of the rights. Do you want to have your company own certain rights, maybe own your YouTube show, maybe own these other things under a company so that the company is licensing it? And I'm not a tax advisor, but obviously having a legal structure and then determining what IP is under the legal structure rather than personally owning it is going to depend on, how you're getting paid for that use, doing these deals, all of those things, and potential tax implications.
Yeah, I agree. I mean, I think as soon as they are committed to making this a business, once they, and that's, something that all creatives or all business people, you get at that point where, okay, I'm going to really go for this and I'm going to, file an LLC. And there are tax considerations and admin costs and all that to consider. But definitely, to Nyanza's point, as soon as possible, just to kind of start setting up the foundations.
The only thing I'll add here is I think the tax advantages of having a loan out company, the sort of like income threshold past where you need to be to where that becomes important to you. But separate from the idea of a loan out, which is kind of limited in terms of the legal liability shield that it forms for you, it really doesn't give a whole lot of value there. Um, but if you're a creator and you're beginning to hire people, if you're beginning to sign lease agreements for space,
Mm-hmm.
uh, you're doing larger commercial partnerships. You're operating a business. You've got studio space. You're working with independent contractors who, maybe you're hiring performers in your videos. At that point, you really do need to have a proper business, and you don't want to be doing that as an individual.
And that is now going to that space, right, where we now have content creators who have legitimate businesses set up. They're doing joint ventures, they're doing investment deals, they're doing production deals with other large companies. And to Matthew's point, like those are going to be company foreign partnerships.
Exactly. Exactly. And let's move on to the next slide regarding monetization strategies. So, as a creator brand, partnerships are growing more complex, right? We're seeing deals that go beyond one time payments, now including equity, long term rights, and even AI usage. So, legal advisors are key in helping creators navigate these terms and protect their interests. So, with that context, I'd like to ask a few questions about how you approach those evolving agreements. So we're seeing more creators ask for equity in partnerships. What legal concerns do you consider when structuring those deals?
Yeah, I mean, this really taps into my thesis for the space, which is that creators should be owners, and when they're collaborating with brand partners, it's a unique opportunity for the brand to get access to a certain demographic and to get access to a very efficient form of reach. And so I just believe that creators should always approach everything they do from the perspective of an entrepreneur who wants to own everything that they're promoting, and not just be sort of work for hire. That's not going to work for every deal, and for an agency run campaign where they're renting reach across 1,000 creators, that's not the approach to take. But for larger partnerships where the creator is being engaged by an earlier stage company, and they're really kind of at the formative stage, providing meaningful value and helping that new brand to break through to an audience. Um, I just love this model of the creator as owner. And so there are a bunch of legal considerations there. Some of them are tax driven, and some of them uh, are product driven. You know, if you're a creator who's a joint owner in a business, um, you do have to be careful about validating the business that you're working with, and so you want to make sure that you're not taking on things like product liability risk or operational risk for the business. You want to make sure you're covered by their insurance policies. Um, and you want to make sure that the form of equity or ownership style ownership and control that you take in that business is tax advantaged for you. And there's many different models that you can use to ensure that, but it's critically important for talent to make sure that they have a good business lawyer working with them as they take equity style arrangements in brand partnerships.
As you're
I would
seeing,
say along those lines that, especially in terms of thinking about when you're taking equity, two things come up. One is that a lot of times people are having conversations and they're saying, you're going to get a share of the company, you're going to get a share of the company. And defining, is that an actual equity share? Is it a revenue share? What are you saying when we're sharing? Let's clarify what that is. And on the equity side, then thinking about like, how big is this venture going to be? Because are there vesting schedules? Are there dilution risks? What happens when the company ends, right? It's kind of going back to Tisha's point. There has to be some sort of termination clause or some sort of out at some point that has to be considered on the front end. So we want to be smart about those things. But part of it is just structuring, what does that equity piece look like? When, again, maybe does it vest? How is it, like a true ownership, or is it just an equity piece? And leaning into, for sure, you want that to be an ownership piece because they are bringing IP, they are bringing a value, and a lot of times they're also bringing their own financial to the partnership. And so making sure all of those considerations are taken into account.
I think those are great points. And it so varies in the sophistication of agreements that are produced or presented depending on the company. And you can't assume that just because a company says, hey, we'll give you 5%, and in a very short agreement, it's missing a lot of the points that Nyanza just pointed out. So really being aware that you don't trust necessarily the level of sophistication of who you might be dealing with.
no, definitely appreciate your insights regarding this space because as we see more creators having large followings and getting these brand deals, right, that is something that they should be pushing for. In terms of advising creators on specific brand deals, right, what are the key and legal business factors that you evaluate before recommending that they sign or renegotiate?
Well, I think we talked about the biggest one, which is the ownership piece. We also mentioned the exclusivity. Again, that big line of what is the actual usage and then determining what those fees are. And it's very interesting, again, as the um, creator economy has grown, the types of fee structures have evolved tremendously because it's not just a pay to post. And then is there some sort of performance? Is there additional content to be created? Is there some sort of hybrid payment model? Is there payment over a period of time because there's a long-standing engagement of multiple um, posts, content, et cetera, that's created over a long period of time? Like all of those things go into figuring out the value proposition, but also making sure that the talent or the content creator is protected.
As you are drafting these contracts, right? And also another layer to like contract negotiations across, different aspects of the entertainment industry is AI and how AI fits into this, right? Have you noticed any new or evolving clauses in influencer contracts recently, right? Such as AI replication rights or platform usage terms regarding AI in this space?
I
Yeah,
haven't
so I
seen
was,
it. Oh, go
go ahead,
ahead.
Nancy. No, you
I
go
was going to
ahead.
say, I haven't seen it specifically in deals yet, but we definitely talk about making sure, April, for sure, the replication rights or being able to use And by the way, this is across the board right now with all talent in terms of protecting, their name and likeness, et cetera, and how it's being used. So I think it's just a bigger, broader conversation that happens to overlap in this space.
Yeah, very, very much so. We're doing a lot of deal making, uh, helping to build AI models through data licensing. And so we're seeing a lot of the contractual language around uh, how content is licensed into models, how it might be used, the parameters and restrictions around its use, and um, indemnity risk around those kinds of uses. And some of that is informing the way that we're thinking about talent agreements. It's now very common in a traditional talent agreement, an actor deal, a director writer deal, to have language specifying how artificial intelligence may be used in that project to protect against the use of a talent's personal attributes through AI to give talent some level of control over how AI is interacting with their personal attributes or their other work product. And that's really, candidly, I think driven by the recent the newer guild agreements that protect talent from certain types of uses of their work product through AI. Those guild agreements obviously don't really exist yet for creators. And so I haven't yet seen a lot of language in creator deals relating to the use of AI, with the exception maybe of language saying that the results and proceeds of their services can't be subsequently licensed into a third party model without their approval. Um, but I think it's an interesting question. It's something that, especially for the larger creators out there, they should be really thoughtful about is thinking about the fact that if you're doing a deal with Meta or Amazon or another one of these large global tech platforms that are developing AI products, how should you be thinking about making sure that your name, likeness, and other performance attributes are not being fed into models and then through the development of synthetic data being turned into, sort of an AI-driven competition for your own work, which we know is going to emerge quickly.
No, definitely. I mean, with AI, I mean, it's not going anywhere, right? And across the board, we've seen it in actor deals, right? But in this space, it's very interesting. And so we will touch on it in a later slide and we'll go in a little deeper into the conversation. But yeah, it's just wanted to get your insights early on so that way we know like how should creators even think about AI, right? And so thank you for that insight. So let's move to the next slide. Common legal pitfalls. So with so much content being co-created, right, remixed or built in on trending media, questions around ownership and licensing are more important than ever, I would say. Yet many creators still move forward without clear agreements or a full understanding of the risks. So let's talk about how you handle these IP and content rights challenges in your work. So who typically owns the content and creator collaborations? Because there's a lot of co-collaborations going on, and how often is that actually spelled out in writing?
Well, it comes to us when it falls when it's not in writing and we end up getting it because there's a breakdown in communications. So
That definitely happens, right? Because we do see a lot of collaborations between content creators, which is different than collaborating with brands, right? And so in that space, that creates a different scenario of if I am, I have so many followers, you have so many followers, we're working together on creating content, what that looks like. But it's just, again, as you're growing, being smart about when are you going to need advice? When are you starting to document and put this language in contracts? So for future use, when a brand maybe does want to come and license the content that has been jointly created, what that looks like, and also making sure that as you're creating content, it does not include potential IP, existing IP that might infringe upon a third party's rights when you're going, again, whether it's collaborating with another content creator, doing a deal with a brand, et cetera. And I mean, it all goes back to ownership, but that is a piece of like, there's a lot of repurposed content, as we know, on the internet everywhere. And so one of the questions that comes up with AI, right, is even source. But that also happens just with repurpose and reuse content, where it's like, who is the original owner? How is that incorporated? Making sure that that original owner isn't being infringed.
I'll give one maybe specific example around this question of creative collaborations and ownership. This is something I've seen happen multiple times now, where a couple of creators who sometimes don't know each other that well, or sometimes they're great friends and they have great chemistry, will start a podcast to be a video podcast, and um, it takes off. It goes well for a while. They start to get into the rhythm of producing weekly. The audience grows. And then one of them gets tired of the work. One of them is doing more work in terms of development or editing. One of them is more responsible for bringing the brand deals in than the other. Maybe one of them has sort of a life change, wants to move, relocate, or other creative things come across their plate that are more interesting. Um, Usually, they did not put something in place when they started the podcast to define who owns what. What happens if we want to stop someday? Um, and so I've seen multiple disputes now where talent end up, someone steals the show by rebranding it and bringing on a different host and taking control of the social profiles and stuff like that. And then, one of the others is left hanging, and lawyers are then hired to try to unwind it all and figure out how to resolve things. Um, this happens a lot, and it's partially because this media format is a really high growth space right now, and because the barriers to entry are low, and it's one of the most kind of accessible ways for charismatic personalities to kind of test ideas. Um, the problem being obviously that you can very quickly create a lot of value through that format, and then have to figure out, have to go to court to figure out how to dispose of it in a dispute. So um, this is one thing where I try to encourage clients to, if you're going to even just pilot, if you're going to do a 5 episode test, even if it's on socials, not even on YouTube, whatever it might be, just scratch some thoughts down, get something on paper of some kind. And we have these little templates that we give our clients sometimes, which is just a little one sheet for here's how we're going to address these 5 issues. It doesn't have to be expensive. It doesn't have to take a lot of time, and it can save an enormous amount of heartache down the road.
No, definitely. I know we see that a lot. I mean, that's a common trend, right? When creators are starting out, they want to collaborate by working with other creators, and then oftentimes than not, they don't have anything in place, and that's when issues later arise. As an attorney that's advising, right, content creator who's entered, let's say, on a collaboration with multiple creators, and they've developed this type of content, who has the right to that piece of content, essentially? Because one probably recorded it, the other one came up with the idea behind it, right? And so there's different aspects and different types of input. So as an attorney dealing in this space, how do you go advising this type of this creator that would come and seek advice?
I think that goes to what Matthew was saying, but I also know of specific deals where there are content creators. I had a client, they were launching a podcast and they basically just hired the 2 other folks because they knew they weren't going to be on the production side. They were really there as talent, right? So even though it feels like a collaboration, at least they considered you all are not going to be contributing as much as I am because it was also they were funding it. um, and so they were not contributing funds, they were not going to contribute to the production of it, et cetera. And so, but it's just trying to get something basic in writing that at least has those basic parameters of what's what on the front end just makes a huge difference.
In terms of trends, right? Especially across TikTok, there's multiple trends going on that just people like mimic, what somebody else is doing, and that's part of like the interactive aspect of a platform like TikTok. So, how does would a content creator that, let's say, came up with like a dance routine, right, or something, and it became highly popular, and then another person comes and replicates that, and then they're actually using that to monetize it, right, and make a profit. Do they actually have like some sort of claim or some sort of, I guess, they can address with respect to that, especially how the platform is that you're used to seeing trends and just copying them or using um, particular dance routines or things like that. So what are your thoughts, or have you had clients that feel like they have like a claim regarding that aspect?
I think it goes to basic copyright law. I mean, in your example, I think choreography is copyrightable. And how unique or how different it is whether it is how strong the copyright is questionable. But you know, I th this also leads to kind of going back to what we were saying about ownership. And if you have ownership, then do you also comes with liability of what you are owning, as far as if you're infringing or others are infringing upon you. So it all kind of starts to tie together with these issues. If you are the owner, then you're the owner of the copyright. Are you a copyright infringer, or are you a copyright infringee? And so, and then the indemnification from if you are have a deal with a brand, if that falls on you or the brand. So all the dots start connecting in all of these issues, which is kind of makes our job fun.
That's the creative part, right? As all of these things change and evolve rather quickly, it is a matter of figuring out best case scenario and best practices for how these relationships work, which is very interesting.
Definitely. Let's move on to the next slide. Well, the case study example. So I'd like to invite each of you to share an example, if you have one, of a brand deal that presented unexpected legal or business challenges for the creator. So this could involve issues like missed payment milestones, lack of approval rights, or even the misuse of the creator's content or likeness. From your perspective as transactional attorneys, what went wrong and what would you advise creators or their representatives to look out for to avoid similar issues in future deals?
Whenever I've had an issue, especially relative to deliverables, even if the contract was very clear on what the expectations were, there were always times where either the brand didn't feel like it was fully deliverable and they're trying to figure out, well, why didn't you do it this way or that way, or et cetera. There's still like interpretation issues that come up with what is actually deliverable, especially I do a lot of, again, long-term partnership kind of deals. And so there's the monthly deliverables, there's different performance deliverables, there's things that are over a period of time. And again, in that instance, it's really an interpretation of, well, what is considered delivered and what does that look like, and making sure that we can say the deliverables are X in the agreement, but then making sure when it's actually happening that it's consistent with the expectations of both parties.
I see a lot of inconsistencies in
Tisha,
contracts.
do you have any like type of, and talk a little bit more
I'm
about?
sorry, you froze for a second.
Oh,
I think, Tisha, you're going to make a point anyway, so go ahead.
Okay. I was going to say I see a lot of inconsistencies in contracts, and not intentional, but just by carelessness. And that, for example, if the creator has ownership, but the brand has approval controls, or the creator has ownership, but there's still a work for hire clause, like, not hidden, but like, somewhere in the language. And so just being aware of those inconsistencies just by human oversight more than anything.
Yeah, I would say, candidly, we work with a lot of talent, and it is often the case that the talent are the party that didn't quite meet their obligations under the agreement, just as often as there might be a problem with the brand side. And usually that's some version of, they lost interest, they lost focus, they were unreachable. Again, one of the kind of fun challenges of the space is that as your talent grow quickly, they're learning to be professionals as they're building their profile, and they're learning how to work with brands and agencies. Um, we do see a fair number of sort of discussions around deliverables and timing and termination, and what happens in the event of a termination. Those termination conversations are often a little bit murky. It's usually the case that there's some foot fault on both sides. Um, so one of the things we've learned to make sure this is often not a part of the standard template, and something that's important to make sure that you negotiate for is to get paid for all the work that was done prior to the point of termination. And you can measure that in different ways. It can be prorated based on time or based on deliverables. I like time, especially for deals where the creator is going to be putting in a lot of effort to develop concepts for the brand before they're delivering content. Um, and then I often like a kill fee on top, and there's a lot of negotiation around how you measure those kill fees and when they're payable and not. But I think it's an appropriate ask. You should always be paid for some version of prorated work done to date, and then try to get something on top.
Well, thank you so much for your insights and the deals that you've worked on. Let's move on to the next slide regarding emerging regulations. So we talked a little bit, about AI, and now, what would you say generative AI and synthetic content are complicating IP, right of publicity, or ownership law in the creator space? We talked about this already, but anything, other thoughts that you have regarding this topic that's evolving?
I think that goes also back to what Matthew mentioned about indemnification, right? And because we want to make sure that if there is an FTC issue or there's any kind of infringement issue, whatever, that the proper parties are responsible for that. And that's part of the regulation is making sure the rights aren't being infringed. And then also identifying when these are true ad-based partnerships, et cetera. And so if there is a gap in the recognition of that, that those things can be quickly addressed so there's not a bigger fallout from it. And a lot of that is just communication, right? Again, when you're dealing with longer term partnerships, these are communications that are happening all the time. A lot of these partnerships then extend because both parties are getting, great benefit from it. And it's just continuing to discuss what it looks like for both parties, so that they are both doing what is needed to avoid any regulatory issues.
In terms of like FTC trends, right? Should creators and their legal counsel, what should their creators and legal counsel be watching closely right now?
Well, it's very clear that the brand endorsement or sponsorship or paid whatever needs to be clear and conspicuous. That they've made that clear. And a lot of examples have come out as far as what that means in videos. It needs to be at the beginning and not like hidden at the end. Hashtags need to be very clear, conspicuous that this is a paid endorsement. So I think that we're actually clear on that one area of the law. But how with new technologies with the platforms of whether it's a reel, whether it's a a story carousel, it is evolving of how, where, and how the clear and conspicuous needs to be addressed.
And we talked about, like there's different unions, right, for actors, and those type of in a sense, creators. But do you see do you see real momentum behind creator unions or collective rights groups, and what legal structures would support them?
I think it would be supported by the existing structures, but I think as creators are evolving, like we're saying, into actually creating productions, creating potentially union productions that are film, TV series, et cetera, even if they're platform based, there is going to be a transition into what is the content that's being created that might be under an existing guild or union. If they're, again, hiring actors to produce a series, whether it's on YouTube or not, it still might come under the guild regulations.
Yeah, I think that's right. One small thing I'll add here is, um, there are probably pluses and minuses to being part of a collective bargaining organization if you're a talent, and specifically around SAG. Of course, if you're a creator and you end up working on a SAG production, a commercial shoot, a certain number of times, you're now a SAG actor, and that's going to have implications for your future engagements. So some talent really don't want the burden of having to be of having the baggage of the minimums and the royalties and the contracts around collective bargaining. We spend just as much time, I think, helping talent figure out like whether or not it makes sense for them to take a SAG engagement as we do thinking about, how can talent collaborate and collectively bargain for protections.
Well, thank you for your insight on that because there's been a lot of conversations regarding whether there should be a union that supports creators or not, right? And so it's great to hear your perspective on this. And we can go to the next slide on what lawyers need to know. So as this space continues to mature, continues to evolve, creators are starting to think beyond individual brand deals and towards building long-term value, whether through licensing, equity, or even exit strategies. At the same time, more attorneys are entering this field and looking to understand how to best support clients in a fast evolving landscape. So to close out, I'd like to ask a few forward-looking questions about where this space is headed and how we can best prepare to serve creators. So how do you think how do you help creators think long-term around exit strategies, licensing, or ownership transitions?
I'll add one aspect because I deal with legacy rights some. So considering naming a digital executor to your will or trust, thinking about who's going to take over for you in the future. So that's not something that's on the top of most people's list, which is why I'm mentioning it because it usually gets overlooked.
I think an important distinction to be made is that a lot of these deals are business deals. They're not entertainment deals, right? And so that's also consideration when you're coming into representation of these types of talent. Just the deal structure differently because it's not that they're getting cast in a movie or cast in a commercial or they're doing talent deals in the same way. These types of collaborations that we're discussing, these types of partnerships are business deals.
Right, they're building their own businesses and difference as opposed to thinking about this as an entertainment transaction and entertainment law transaction. So in terms of like, because I know we've been exposed, right, to like TikTok being banned, right? And that's like an ongoing issue that's might or might not happen. So when talking to creators, right, and how they're like starting off doing a few posts here and there, they start building their following, and what advice do you advise them early on? So because in terms of sustainability, right, if TikTok's let's say removed or then that's where they have the majority of their following or something happens the creator content that they've developed is no longer sustainable. So how do you go about advising them early on that to think about ways, exit strategies early on and thinking ahead beyond, what they're working on at presently?
You know what? We didn't touch on this, but I think it's important to mention that This is not only about the IP being created, it's also about the data and the analytics that the content creator has, right? Because this is about accessing their followers, their impressions, and all of those things. So that's also a consideration. And who owns that? And there are some brands who are saying, hey, not only do we want you to post this or expose this or create this content for us, they also want access to that. But when we think about, again, the TikTok 24-hour ban, some of those creators are not as savvy about and should be advised about how are you protecting your data? How are you protecting your analytics? How are you connecting with your followers? Because if TikTok goes down, how do you get in touch with them, right? So then there's a transition of whether it's email, database, other ways that that value proposition can be contained and used in another way and or on another platform.
Exactly. Well, thank you all for sharing your insights about this matter. I really want to open it up to the audience before this program ends and give them an opportunity to ask their questions. So I do have a question here that says, Matt and team, can you commentate at all on the wave of purported class action suits naming both brands and influencers this year? For instance, Revolve, Celsius, that vodka company in Illinois. They are all using insufficient disclosures, not just non-disclosures, to allege incomplete FTC compliance as a trigger for state consumer protection law claims. They're coming from the same firms, following the same format, and casting plaintiffs with flimsy actual damages. I would have brought this bottle of vodka, for instance, I would have brought this bottle of vodka had this attractive woman place the hashtag ad, disclaimer, further up in the text, etc. How can we play proactive defense?
I'm not familiar with this litigation. It's interesting. I mean, how can we be proactive? I guess I'm not sure from whose perspective, but as like if we're regardless of who we're representing, I think it's very important to make sure that the disclosures are clear. So when we're working on behalf of talent, like that's absolutely on the checklist to make sure that all the disclosures are being provided. One thing I really don't like about the brand deals in this space is that they often try to allocate FTC risk to the talent, even if the brand is responsible for giving us the form of disclosure. So we try to negotiate a different outcome. We try to negotiate for the brand to take FTC risk and to have them provide us the forms of disclosures that they want us to use. Sometimes we get that, sometimes we don't. But in general, regardless of who's got the contractual indemnity risk, our clients should be making absolutely sure that they don't try to cut corners on those disclosures.
I have another question here. Thank you, panelists. Could you speak to the importance of factoring trademark infringement liability when structuring deals, particularly in light of cases like Molly Sims, where an influencer was pulled into a trademark lawsuit despite simply following the brand's direction?
I think that goes back to what Matthew just said about making sure that the indemnity language is there and that whatever trademark IP information that is being presented from the brand for the creator to use, that those deliverables are clear and who owns that and who's going to defend any claim that comes up because of the use is set out in the deal.
Thank you, Nianza. I have another question here. Also, many influencers and creators operate with minimal support, and even with partnering with major brands, they often don't fully appreciate the need for legal protection. How do you, as advisors, help educate or convince your clients, especially smaller creators, of the importance of having legal safeguards in place?
Well, really, I think, again, it goes back to this idea that if you're really growing a business and you're really now committed to doing this and making this your business, that you have to start being smart about it. It just is as basic as that.
Yeah, I tell them scary stories.
Or that, I was going to say, like, somebody's going to steal your brand and then you won't get it.
We've all got enough examples at this point of things that have gone sideways, creators who have lost exceptionally valuable opportunities because they didn't spend a little bit of time and money up front. So
Yeah, unfortunately, clients a lot of
Absolutely.
times come to us once they've had something bad go wrong, or something wrong go bad.
There's another question regarding CapCut. So CapCut recently updated their terms of service to give themselves broad license to use, modify, publish creators' content, including unpublished drafts, and to grant similar rights to third parties. Is this type of broad IP usage typical of or becoming more typical of platforms like CapCut? In your opinion, could this signal a trend of platforms claiming greater IP rights over users' work?
It's an interesting question. One of my partners deals with this type of question often, and those terms of service changes if they're not presented carefully and in the right way. The FTC has taken a really hard look at platforms that are trying to initiate a land grab around data by updating their terms of service to give them broad rights to take that form of data and use it in ways that weren't initially intended for the consumer, including, we've talked a little bit about AI uses, including in AI context. I think it's really risky and inadvisable for a platform to try to um, make those changes to their terms and start commercializing consumer data without being really, really explicit about what's happening. And I think they're opening themselves up to, I mean, I can't speak to this case specifically because I haven't read those terms and I'm not super familiar with CapCut, but in general, when I'm working with a platform, we're extremely careful, to make sure that when they update their terms or if they're using data in ways that aren't very obvious to the typical consumer, that we initiate term changes really, really loudly and boldly so that there are no surprises.
I know we're up on time, but I just have one last question here. Do any of you ever use fixed fees and how?
Yes, and it depends.
Yeah, I mean, more typically for large transactions where it's a type of deal that we do frequently, and it's fairly easy to predict, the level of work involved, and um, but that's atypical for us. It's we usually do things hourly or sometimes on a percentage basis for talent.
Sounds good. Well, thank you so much, Matthew, Nayantha, and Tisha, for coming on this panel and sharing your insights with all of us.
Thank you.
Thank
Thank
you
you.
all.
Thank you to the Beverly Hills Bar Association for having us.
Absolutely. Thank you.
You may be eligible for CLE credit in your state. Visit bhba.org/podcasts for more information.